That's surprising.
Yes,
my daughter also has an argument because I've got an issue in this application. But my heads of arguments were handed to the state this time. I wish to apologize if I to make all this. My heads of arguments are under the heads of arguments on an application on behalf of accused number 3 to be taken to enter Sargeant before examination of Sergeant Mabasa. Introduction. The government of this application, my God, is for accused number 3 Mzansi to be taken to the dentist for dental examination before the commencement of cross-examination of my academic colleague, advocate, in order to challenge or controvert the evidence tendered by the state witness, Sergeant Mabasa, in evidence in chief. The state vehemently objected to this application on the basis that the stage at which such an application is made is unwarranted, as the accused would be afforded an opportunity in his defense to challenge this evidence. My God, it would be proper for me to sketch just the background of this application as the reason why we find ourselves here today. The application was made based on the evidence of Sergeant Mabasa when questioned by the state on what he observed in accused number 3's teeth, which is contained in accused 3's image in exhibit S, capital letter D in bracket. The response that Sergeant Mabasa gave was to the effect that on the accused upper jaw, from the left side of the mouth, on the second tooth from the left, he observed that the accused has a bald tooth. It then prompted accused number 3's legal representative to make an application that accused to be taken to a dentist for dental examination before he commenced with cross-examination of Sergeant Mabasa. The state objected to this application. The constitutional provisions, my colleague advocate Mzansi had referred to section 35(3) B, small letter B in bracket, which reads as follows. Every accused person has a right to a fair trial, which includes the right, small letter B in bracket, to have adequate time and facilities to prepare a defense. The most relevant provision, my Lord, for this application, which I find it relevant, is section 35(3) I in bracket, which reads as follows. Section 35(3) I in bracket of the Constitution of the Republic of South Africa, Act 108 of 1996, the Constitution entrenches an accused person's rights to accuse and challenge evidence, and it provides as follows. Every accused person has a right to a fair trial, which includes the right to accuse and challenge evidence. Close quotation. The right of an accused to a fair trial requires fairness to the accused, as well as fairness to the public, as represented by the state. It must infuse confidence in the criminal justice system with the public, including those close to the accused, as well as those distressed by the trauma of the crime.
Why are we back at Advocate Nxumalo's heads of argument for why Umthobisi Prince Ncube, accused number 3, should go to the dentist? Well, it's because it's relevant, okay? It is relevant. Why is it relevant? The state is making a fool of themselves because this all started, guys, if you remember. The state wanted to introduce their new exhibit SD in Dundon, and the defense said, don't do it. Don't do it, Snipegile. Don't do it. And what did the defense do? They went ahead, they gave their heads of arguments, and what did my lord do? He endorsed it and said, bring back Mabasa, bring back Ndlovu. Little did they know that is the worst mistake they could ever make, and that this would actually be the nail in the state's case. Now, why did I go back to Advocate Nxumalo's Thuleles heads of argument. First of all, why does nobody like this man? Why did nobody tell him, your collar, sir, your collar is not giving inside Judge Arata's courtroom? But it's such a distraction, and I just keep laughing. I'm like, is this a gangster statement? Is this a bold move? Is this him standing out of character? But I digress. Here is what he said, because the audio is really bad. I tried to clean it up for you guys, but it's bad. Okay, at the time, you already know the cameras and the good audio. I guess they went with Cyril Ramaphosa, President Cyril Ramaphosa, to the Canada, or they went to the Thabo Bester trial. I don't know. All I know is the SENZO MEYIWA trial was left with crappy audio, okay, and crappy film, and one camera. We could only see one angle. But such is life. Here is what Advocate Nxumalo opened up with. The state vehemently objected to this opportunity of Mabasa. The state vehemently objected to this opportunity of accused number 3 going to the dentist, remember? Okay. And then this opportunity was presented when Mabasa said on the accused upper jaw, he observed a gold tooth. And that's when Mnisi says, oh my goodness, you've got to be kidding me. And Nxumalo goes on to say, in the Constitution, okay, Section 35(3)(b), every accused person has a right to a fair trial. And then in the Constitution, the very same Constitution that the state also has access to, and my lord, of course, at Section 35(3)(I), it says, an accused person's right to adduce and challenge evidence requires fairness to the accused and fairness to the public as represented by the state. Okay, us members of the public jury, we are being represented by Baloyi and Sibanda. Keep that in mind. Keep that in mind, especially with all that is going down with Mabasa's cross-examination. But don't worry, okay? We're going to go back into that. But I wanted you to remember this little point. I'm going to read it one more time so you are aware why it matters what is going on in that case. Just because you are not part of the accused person, know that you are still represented inside Phakathi within by Advocate Baloyi and Advocate Dr. Ndondoni Sibanda, aka Dr. Edits. Now, Section 35(3)(1) says, an accused person's right to adduce and challenge evidence requires fairness to the accused and fairness to the public as represented by the state. It must infuse confidence in the criminal justice system with the public, including those close to the accused as well as those distressed by the trauma of the crime, aka the Meyiwas, aka accused number 3 and his alleged gold tooth. Okay, now let's get back into here. What else Advocate Zitulele Nxumalo with the raised collar has to say?
When coming to the right to cross-examination, it is a crucial component of a right to a fair trial, and depriving an accused of this right has serious consequences and may lead to crucial evidence being disregarded. With regards, my lord, to the importance of a right to fair trial, I wish to highlight what was said by the Honorable Judge Sargeant, the Constitutional Court Judge, as he was then was, who had this to say in State versus Mundemi. It's a Constitutional Court decision. It is reported in 2 reports.
It's a good law. It's a good law.
Yeah, my lord.
I know that. Enron wrote also.
Yes.
The 2 years.
Yes, it is.
Enron, let's say, okay, particularly there was another decision because made
The State versus Ndongo case.
then Bobo also got rid of it.
Yes.
The new decision makes because believe us, because that case is terminated on the hearsay.
Yes.
Right.
Yes.
But you can go on using the citation. I'm not saying something, I'm just saying the SAS actually says they never opined on that.
Yes.
And then when they went to the Constitutional Court also died.
Yes.
You remember?
Yes, I remember.
That was the development. But subsequently, the latest decision overrules all of that. But let's go on.
Yes. I'm quoting this with regards to the right to a fair trial.
Yeah,
Yes.
right, yeah.
This to say in Singh versus Molin. It's a 2008 Volume 3 SA 608 Constitutional Court decision. I quote.
Yeah.
The right to a fair trial is to instill confidence in the criminal justice system with the public, including those close to the accused, as well as those distressed by the audacity and horror of crime. More importantly, proceedings which little or no respect is accorded to a fair trial rights of the accused have the potential of undermining the fundamental and visceral nature of judicial proceedings and may threaten their legitimacy. Close quotation. The application of the constitutional provisions. The production of this evidence came at the tail end of the state case. The photos that the state introduced through Sergeant Mabasa did not form part of Exhibit S that he testified on when he testified for the first time before this court. It is submitted, my lord, that the state was aware of the description given to him, that is accused number 3, when Brigadier Kininda applied for a warrant of arrest contained in his affidavit, Exhibit ZZ, in preparation of his case against accused number 3. There cannot be any inch of imagination that the state forgot to include them in preparation for their case. In this instance, he has to be given an opportunity to adduce and challenge this evidence to strengthen his case through cross-examination, producing a report from a dentist which would be admitted provisionally in support of his case, and later in his defense called a dentist who combined the report as his witness.
Can they do so?
Yes, they can.
It depends.
Yes,
Not the state.
they can.
They are using it so. They are saying,
Through cross-examination to Sergeant Mabasa,
and then you say,
in support of his version.
that's it, yeah.
Yes, the accused can produce a report
Yes, man, again.
compiled by the dentist to say this is the report, these are the results from the dentist.
That's called, that's something different.
In support,
Okay.
if there is a need, in support of the report, in support of the report, if there is a need. The reason why this evidence was not led in evidence in chief was sketched by the state when making an application for the reopening of the state case. The issue arose at the stage when the state intended to re-examine the investigating officer, Brigadier Kininda. The defense objected on the basis that Brigadier Kininda did not testify on this aspect in his evidence in chief. The reasons advanced by the state on why this evidence was not led was that the investigating officer requested at the time that only certain photos found in the downloads of accused number 3's cell phone should be included in Exhibit S, the affidavit of Sergeant Mabasa. Those photos were also included in the affidavit of Lieutenant Colonel Stein at the request of the investigating officer Brigadier Kininda in order to identify the clothing and dreadlocks of accused number 3. That the main focus was mainly on the clothing and the dreadlocks. The state intended to present the additional 3 photos to show other features of accused 3 that were canvassed during cross-examination by Advocate Mzansi, such as the one truth. That it was only during long adjournment that was afforded to Advocate Mzansi to prepare for his cross-examination that the state was able to go through over 5,467 photos of the downloads. These downloads were given to the defense a while already. In this regard, I not submit that the reason given by the state is misconceived and misplaced because the affidavit of Brigadier Kininda, Exhibit ZZ, in support of the application for a warrant of arrest against accused number 3, states the following at page 4 of 6, paragraph 3.3, line 4 to 7 of his affidavit, and I quote, "Photos downloaded taken of the accused by himself, open bracket, selfies, close bracket, match the description of the accused where the firearm with red dogs, big eyes, and with a gold tooth. This is a suspect that went into the house, made a demand of cell phone and money. He is also the same suspect that shot the deceased in this matter during the struggle with him." Close quotation. The submission by the state cannot be correct because the state and the defense were given indulgence by this court to go through the downloads of Sergeant Mabasa, and out of more than 5,467 photos that Exhibit S was combined in preparation of their case against accused number 3. The affidavit of Brigadier Kiminda was signed and commissioned on the 23rd of October 2020. Sergeant Mabasa testified on the 12th of June 2023, 4 years and 8 months later after Brigadier Kiminda made his affidavit. Sergeant Mabasa did not testify on the photos in Exhibit S, capital letter D in bracket, as it was not included. It is submitted in this regard that the state knew at the inception of this trial what evidence linked accused number 3 to bolster their case against him. The purpose of cross-examination. The purpose of cross-examination is to test the reliability of the witness's evidence, to obtain information which is at the witness's disposal, to weaken or destroy the opponent's case, to substantiate or strengthen the cross-examiner's case, and to put all the disputed issues to the witnesses.
Okay, I for one am always complaining that Advocate Zitulele Nxumalo is living out his name and being too Zitulele inside that courtroom. But let me tell you something. He literally, in my opinion, predicted what we saw as the fall of Sergeant Mabasa in that witness box, because he literally said it in his heads of arguments at the time of the application for accused number 3, Umtobisi Ncube, to go to the dentist. Wow. So Nxumalo says, and I quote, "The purpose of cross-examination is to test the reliability of the witness's evidence, aka Mabasa, to obtain info at the witness's disposal, aka how did you find this gold tooth? I searched and I searched and I searched for the brown bread. To weaken or destroy the opponents." At this point, Sergeant Mabasa is not just weakened, he's decimated, he's destroyed. To substantiate or strengthen the cross-examination, aka Umnisi Wemvula is totally strengthening accused number 3's case in that I never had a single gold tooth. What is Mabasa talking about? He is not a reliable witness. If at all anything, he relies on guesswork. And Mabasa demonstrates this throughout the court. And then when he realizes, man, this is not looking good for me, nobody's coming to save me, Balo is dead silent, Sibanda is silent. Where is Gininda? Not even in this court. Where is Mahola, who put me in this whole situation? He is on his own. And that is when he starts talking about, well, yeah, I searched. I was told to search for a photo with an open mouth. Guys, I want you to pause on that and think that is the level of investigation of the South African police services. How many people are inside Phakathi the prisons with such evidence on full display? This is absolutely ridiculous, and this is why I say Advocate Zitulele Nxumalo predicted what is going to happen to Mabasa. But the state insisted, okay? They insisted on their exhibits SD Ntoni being included. This is sad. As a member of the public jury, this is actually sad to watch. I know it's hilarious. I know we laugh about it, but it is actually sad because this is a representation of many, there are thousands of cases a day, right? Thousands. Countrywide. There's only a few that are screened on national TV for us to see. Nxumalo concludes with, and to put all the disputed issues to the witness, aka I've never had a tooth. Let's continue listening on and hear where else he goes with his brilliance, okay?
The right to cross-examination. In South Africa, the right to cross-examination, to cross-examine the witness is a fundamental aspect of a fair trial enshrined in Section 35(3)(I) in bracket of the Constitution. While the defense generally has a right to cross-examine, there are circumstances where it might be strategically beneficial to postpone or forego cross-examination to gather further evidence. This decision must be carefully considered, weighing the potential benefits of further investigation against the risk of potentially damaging the credibility of the witness or losing valuable time. In this case, minority defense believes that additional evidence is crucial and can be obtained by delaying cross-examination of the witness, Sergeant Mabasa. They might opt to postpone This involves further investigation that accused will be taken to the dentist for examination that will be relevant to the cross-examiner's case. The right to cross-examination is vital. Courts do have the discretion to grant postponement for gathering of further evidence, but this decision will depend on the specific circumstances of the case. Courts will consider whether the postponement or absence of cross-examination is genuinely necessary, and whether it will cause undue prejudice to the accused or the prosecution. In this instance, my Lord, I submit that the postponement of the cross-examination will not cause any prejudice to the accused, because all the accused support the application on behalf of accused number 3. I further submit, my Lord, that there will be no prejudice to the state if such a postponement is granted, because in any event, we are still busy dealing with the state case. The constitutionally protected right to cross-examination acknowledges the crucial role it plays in the adversarial system. Read more on evidence at paragraph 1367, that is 1367, mentions that it is, I quote, "beyond any doubt, the greatest legal engine ever invented for the discovery of the truth." Cross quotation. The court's discretion. The court has a discretion to manage the trial and can determine whether to grant or refuse a postponement, or allow the defense to revisit the witness's cross-examination at a later stage. However, there are situations where a party may need a postponement to properly prepare for cross-examination, such as when new evidence emerges or when further investigation is required. My learned colleague, Advocate Mzansi, had touched base on Section 36 of the Constitution. I've also referred to that section, as well as Section 39(1)(b) and Section 39(1)(c), which deals with that the limitation. I've also referred to those sections, as well as the international law. There will be no need for me to read at the front on the same subject, except to continue in the lot and say that the reason why the examination is required. In this regard, it is crucial that accused number 3, Mzansi Unfiltered, be taken to the dentist, as he denies that he ever had the cold tooth. The examination is necessary to strengthen his case, thereby weakening and destroying the state case. The effect of failure to cross-examine. If the witness's evidence on point of dispute is left unchallenged in cross-examination by a legal practitioner, the state is entitled to assume that the testimony is accepted as correct. It is state law that the cross-examiner should put his defense on each and every aspect which he wishes to place in issue, explicitly and unambiguously, to the witness implicating his client. It is my submission, my Lord, that this application deals with postponement. There is no argument about that. There is no provision in the Criminal Procedure Act or in any legislation which deals with such matters, but it is the aspect that deals with postponement, whether a court can grant or refuse the postponement. It is simple as that. I had to look on issues dealing with postponements, my Lord, and I came up with 2 cases. It's Supersat and others versus Standard Bank of South Africa, PTY Ltd and others. It's an SNK decision. It's EC 14/2023. It was delivered on the 19th of December, 2024. It was decided that the court has a discretion as to whether an application should be granted or refused, which must be exercised in a judicial manner, not capriciously or open wrong principles, but for substantial reasons. Close quotation. And that case listed factors that the court can take into account.
Yeah, I know the case. About the supermarket, it was already like people's accounts with the employees of the supermarket.
Yes. And maybe that the court knows about these factors. Factors which usually weigh with a court in considering an application. The court will take into account whether the application has been made timeously, whether the explanation given by the applicant is fully and satisfactory, whether there is prejudice to any of the parties, and whether the application is opposed. All these factors will be weighed and determine whether it is in the interest of justice, not only by what is in the interest of immediate parties, but also by what is in the broader public interest. The court is generally inclined to grant a postponement if the reason for a postponement is fully explained and justified, especially if justice demands further time for the applicant to present their case adequately. The leading case, which is the second case, my lord, dealing with postponement, which serves as a stare decisis, is stateless, not states, is Mandelsky. Mandelsky, it's M-A-D. Yes, versus Rosenberg. 1949, volume 2, SA 392. It's an appellate decision. I can count that there. Sets out the South African legal precedent regarding the granting of postponement in legal proceedings. The case emphasizes that a court should be slow to refuse a postponement when a party preparedness is fully explained. Maybe it was a typing error, it should be right. Unpreparedness is fully explained, and not due to delaying tactics. The court's discretion in granting or refusing a postponement must be exercised judicially. So what I want to emphasize when one looks in the circumstances of this application is that in this case it was emphasized that the court should be slow to refuse a postponement when the party unpreparedness, that is unpreparedness, my lord, to continue with a cross-examination to a witness is fully explained and not due to delaying tactics. Advocate Nisi has dealt with this aspect of why he could not commence with his cross-examination to Sergeant Mabasa. It is clear that for the reason given was that he was not prepared to commence with his cross-examination. This court, when faced with this application, it has a discretion in granting or refusing a postponement, and that discretion must be exercised judicially. Prejudice is a vital factor in the court's consideration. The potential prejudice to either party must be weighed carefully. The court will be cautious in denying a postponement if it would cause significant prejudice to a party seeking a postponement, particularly where the reasons for the postponement are legitimate and justified. Conversely, if granting the postponement will unfairly disadvantage the other party, the court may refuse the request. In this regard, my lord, when one looks at the reasons advanced by my learned colleague Advocate Nisi for seeking a postponement, they are legitimate and justified. He has indicated that the state, meaning the law enforcement agencies, had this information for a period of 10 years, and the prosecution had this information for a period of about 5 years. So it would be unfair to expect when certain individuals in the criminal justice system had this information for such period to expect the accused, when this evidence is presented on the 12th of June 2025, then to begin and commence with his cross-examination, especially on the issue of taking him to the dentist. In conclusion, my lord, I submit that the application is legitimate. The application for a postponement on behalf of Mzansi that he be taken to a dentist for examination before his counsel, Advocate Nisi, commence with his cross-examination of Sergeant Mabasa be granted. It is over.
Mrs. My Lord, I have no further submissions to add on the submissions made by the defense counsel and by their submissions.
I'll start at the end. Of course, I'm disappointed, okay, that advocate Nxumalo has got nothing to add to the submissions with regards to the application of accused number 3. I guess it's beginning to sound redundant with Mnisi, Ramasipili, and Nxumalo all, kind of supporting the idea and bringing up very similar issues. As you can hear, Nxumalo also had to skip past some parts of his heads of argument because they were already ventilated by Mnisi, and thoroughly so, okay? So from a personal standpoint, I enjoy listening to Nxumalo, okay? I enjoy listening to hearing what's on her mind, how her mind works, and how she would have argued this. That's the only level of disappointment I have. However, I understand why she stood down on this one. I am totally okay with that. However, when it comes time for her to cross-examine Mabasa, my expectation is that she is fully there inside within that cross-examination, because I think if you thought Mnisi's cross-examination is hilarious, I think Nxumalolo's would be beyond hilarious, okay? Also, a selfish part of me wants to hear a female representation all the time. I want to hear what's on her mind. We did hear in the asbestos case how the accused Ucholota had her charges dropped, literally within a trial, represented by her advocate Uloisa, who's also here on these YouTube streets. Okay, I hope she drops a vlog soon because I thoroughly enjoy her videos. No, she does not talk about her cases, but some of us who know, we know. Okay, we know because we've been watching her vlogs, and then at the same time when we saw her in that case, we were like, okay, I know who that is. But I digress. Well done to Advocate Nxumalo. I think he did a great case, a great job in showing that the request for Umncube to go to the dentist is legitimate, and it is not a delay tactic. I have no idea why anyone would think it's a delay tactic to go to the dentist to get a report to prove you don't have a gold tooth. Why would anyone think it's a delay tactic? That is absolutely ridiculous and hogwash. But guess what? He also says, he cautions Judge Rata. Can you believe the nerve of Nxumalo Zitulele? He says the court should be slow to refuse the postponement when Advocate Mnisi explains why he cannot continue with his cross-examination of Sergeant Mabasa. Well done, Nxumalo. I didn't see that one coming from you. Well done. And anyway, his submissions prove that he is not only inside Pagati, the courtroom, but he's present and he is able to follow through and give a heads of argument. Well done. I'm going to end this here because I don't want this video to be too long for your Sunday. We're definitely going to go live today, so make sure you keep your eyes peeled on that notification. Also follow me on Facebook, because just in case the YouTube and Dundunny notification isn't working, I'll also post a message on Facebook when I'm live so that you guys also get that notification. And if you're not on Facebook, that's okay. Okay, that's okay. Just keep checking. I don't have a time yet to give you because I don't want to commit to a time and then I don't make it. Okay, so let me end it right here. Thank you so much for watching. I'll catch you on my next upload. Bye. Of course, I want to hear your thoughts in the comment section. Don't forget to leave me a like and to share this video. Bye.